Hear ye, hear ye, hear ye, all parties having anything to do before the Honorable First Justice Beverly Nunn, now sitting in the Canton Superior Court within Fulton County and Norfolk. John Day, your attendance shall be heard. I'll say the Commonwealth with the court and proceed.
Judge 22 CR 117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Adam Lally for the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Good morning, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right, so to begin, and I have all the motions in limine. I'll talk about how exactly we'll go through them in a minute. But first, so in reviewing the motions in limine, I mean, clearly the defendant has an absolute right, a constitutional right, to present a third-party culprit defense, but counsel is well aware that that is not without limit, right, from the case law. Now, the defendant has stood here, defense counsel has stood in this court repeatedly, stood here and in other venues and in their pleadings, espousing various third-party culprit theories or scenarios. But now that it's time to actually try the case in the courtroom, I don't have a motion from the defense to admit third-party culprit testimony. So, and as you're well aware, I have to make findings before any mention of any third-party culprit evidence or even an opening goes before the jurors. You know, in order to admit it, given that I have no information at all, I mean, I don't know who the third-party culprit is, even after reading 4,500 pages of discovery. I don't know what motive a third-party culprit might have. I don't know how it's relevant. I don't know if it's remote or if it's current. I don't know if it's speculative or if it's relevant. I don't know if it will prejudice or confuse the jury. And if it's hearsay, I have a whole other series of factors I have to consider. So, Mr. Yannetti, are you pursuing a third-party culprit defense?
We are, Your Honor, and I'm prepared to address that. The Commonwealth has raised the issue, and I am prepared to address that today.
So you filed your motions first, and you did not raise it. So if the Commonwealth had not raised it, you did not move to introduce it, correct? I have no motion from
No, I
from
understand.
you about it.
I understand, Your Honor. If you'd like something in writing for us, we can do that. I have a full argument prepared.
All right, so who is the third-party culprit?
We are under no obligation to name any specific third-party culprit.
How am I supposed, so you're prepared to argue all this?
I'm prepared to argue it, Judge.
All right, so we will get to that when we get to the Commonwealth's motion.
That's fine.
Now, the second thing I want to address, because again, it's very important at this point, the motion regarding the DNA, regarding excluding the DNA. Mr. Lally, why should I not allow that motion?
For a couple of reasons, Your Honor. Number one, what I can provide to the court by way of update is that most of the testing with regard to that item is complete. So first and foremost, the item is hair. That was confirmed by the Bodie testing prior to them conducting any sort of mitochondrial testing. The mitochondrial profile, the partial profile that was generated in regard to the hair sample is complete. The mitochondrial DNA profile in regard to Mr. O'Keefe's sample is complete. The preliminary analysis that I received by way of email from Bodie yesterday indicated that they were consistent with each other. I asked for some sort of preliminary report or something that I could share with counsel based on their lab's accreditation. That did not permit them to release anything by way of a report prior to it going through a full review process. My understanding is that not only that process, but the entire lab file should be produced by Tuesday. On top of that, what I would state as far as any sort of prejudice the defendant appears that they've suffered as a result of that. There is still zero reciprocal discovery that I've received in regard to anything from counsel. And then part of the delay, at least a portion of the delay in this specific testing, as the court is aware, as you've had a chance to review Bodie Technologies' observance policy as far as outside experts, there was a significant delay in hearing from counsel and for the defendant in regard to whether or not they wish to have someone present prior.
How long a delay?
I believe it was at least several weeks, if not a month. I mean, we spoke about it in person in December, and I don't believe that I...
My order was in November.
Correct. So when we received your order was in November. What took a little time on our part was to get the samples taken from the troopers in regard to the other testing, and in order to get all of those items shipped and transported from the MSPCL to Lorton, Virginia to Bodie.
When was that done?
Late November.
Go ahead.
Then there was a evidence viewing, which both counsel attended. We spoke about it there. I think that was December 1st. And then I waited a few weeks, never heard back, followed up on it, and eventually heard back with regard to them not wishing to have anybody present for that.
When was that?
I don't have a specific date offhand, but
I need you to find it.
I can.
All right, so I didn't know that the defendant decided not to have somebody there.
Right.
And that prolonged it? They weren't able to go forward, right?
Yes.
How long will it take you to find that information?
Shouldn't take too long. I would need to check my email.
All right, I'm going to take a 5-minute recess.
Thank you.
Court session.
What are you handing me, Mr. Lally?
No, it's an email from Mr. Yannetti on December 22nd confirming that they do not wish to have observation for testing of the hair sample at Bodie.
All right, so that was about a month after my order?
Correct.
All right. And the defendant's asking me to exclude this in part because of the late disclosure of the information.
Yes.
All right, I'll hear from the defense on this, and then I'll give you an opportunity to address it, Mr. Lally. All right.
Thank you, Your Honor. I'd first like to address the timeline that Mr. Lally has just explained to the court. First of all, we were not made aware that we were allowed to test based on Bodie's protocols and procedures until December 1st. We were given a letter saying it would cost $21,000 for our expert to sit in on that testing. We reviewed that letter. We told Mr. Lally that it was most likely we were not going to have someone independently watch the testing because of the price.
When was that?
December 1st.
When? December 1st?
On December 1st. We
Okay.
confirmed that in writing when he emailed us again on December 22nd. And I would note for the court that Bodie did not receive the hair from the Commonwealth until January 11th.
Okay.
So there was no delay on our part. As the court knows, to date we have received no reports from the Commonwealth regarding Bodie Technologies' analysis of the DNA. The Commonwealth has engaged in repeated and inexcusable delays regarding the testing of this particular item of evidence, which at this point is sanctionable. The hair has been in law enforcement custody for more than 2 years, Your Honor. On February 1st, 2022, Massachusetts State Police criminalist Maureen Hartnett purportedly recovered a hair from the bumper of Ms. Reed's vehicle. For a full year, the Commonwealth did nothing. Finally, on March 6, 2023, criminalist Maureen Hartnett got around for the first time.
Sorry, criminalist department? Is that what you said?
Criminalist Maureen Hartnett
Okay, yes.
got around to conducting a visual inspection of that hair for the very first time. On March 6, 2023, she opined that it appeared to be human. However, subsequent discovery produced by the Commonwealth revealed that she had failed her proficiency test in that precise subject matter only 1 month prior. Then, on August 25th, 2023, the Commonwealth submitted that hair to the Massachusetts State Police Lab for DNA testing, and it was forensically determined that no human DNA was detected. Almost 6 months later, the Commonwealth made their third attempt to find evidence establishing that the hair was somehow probative in this case. It is now 4 days before trial, and we are told that we're going to receive this on the day trial is set to begin. Pursuant to Massachusetts Rule of Criminal Procedure 14C, subdivisions 1 and 2, the court has the discretion to exclude evidence based on the Commonwealth's failure to comply with its discovery obligations. There's no excuse for a 2-year delay. We immediately conferred with counsel when he notified us as to what the requirements were going to be if we decided to have an expert present for testing. We got back to him the day that he emailed us following up about that, and they didn't even bother sending the hair to the lab until weeks later. So I don't think it's fair to blame the defense for a 2-year delay in this regard. As the court may know from the notices of discovery, we've received an overwhelming amount of evidence. This week, last week, the week before that, we're on the eve of trial. It is not fair to throw at us yet another item of evidence that we have to retain an expert to assess. We have to review, we have to make tactical decisions. That's not a fair position to put the defense in. We've been asking for a continuance. I think the only fair thing if the court is going to force us to go to trial is to exclude this evidence.
Okay, thank you very much.
Thank you, Your Honor.
Mr. Lally?
Yes, Your Honor. Again, not faulting counsel for any sort of 2-year delay period, but there was a period of time, given sort of the close nature of when the Commonwealth is receiving this information, that a couple weeks, or a few weeks in this case, do matter. The other point I would make as far as, again, as far as the defendant being prejudiced, this isn't evidence that I anticipate introducing in the first day, the first week, or probably not even the first month of trial. So whatever time counsel needs in order to retain an expert, run that by an expert, run that by one of their experts they already have, I don't know that, whether or not they have any experts, because again, I don't have anything from them. So as far as ample time, I would submit that there's more than sufficient time once the report is received for counsel to make use of it in whichever way they deem appropriate. And for that reason, and I'm certainly not asking the court to continue the trial date, but for that reason, I would ask that the motion to exclude be denied, absent any prejudice to the defendant.
All right, so I'm going to take this under advisement. And I may as well tell you that the best way, I think, for us to proceed with the rest of these motions is because they were filed so late, which I understand they were filed, just to be clear, I know they were filed by the deadlines, but so close to trial, I don't have written oppositions, really, unless you both raised independently the same issue. So what I will do this morning is, my intention is to hear from counsel, to hear at least from the other side, if the motion itself is clear enough, but to hear from counsel. Then we'll take a break, and at 2 o'clock, we'll come back, and anything I can decide, because I know you're preparing this weekend to go to trial on Tuesday, anything I can decide by this afternoon, I will. Anything that I cannot, I will let you know. And then we'll do housekeeping, which I consider, including, though it's certainly a very important part of the case, jury voir dire in that. So that will come at the end of, that will come this afternoon. So starting with the view.
Your Honor, I was just going to notify the court, to your discretion, there are a number of motions that will be unopposed. I don't know if
All
you
right,
want
so what
to-
I'm going to do with that is the Commonwealth filed a very helpful list of what their numbers. We have, of course, the paper number, the docketed number. So when I get to that, we'll just go through those quickly.
Whoever the court wishes.
All right, I appreciate that. So you, well, I'm probably starting with one. You could have saved yourselves time in writing the motion regarding the view, because you both want a view. I will conduct a view. You need to talk because you have different locations.
Yeah, and you know, we've, upon consideration, Your Honor, the Commonwealth has asked for a view of 34 Fairview Road. We would be satisfied with a view of...
So you don't need to go to the waterfall?
I think that we can just agree to go to that one location.
All right, so you all figure out the view. I am going to take under advisement your request of the defendant coming with us. You know that there are all sorts of things I have to consider before deciding that.
Thank you.
So that part is under advisement. Before the end of today, figure out exactly what you want to do with the view. Mr. Lally, your office will provide state police escort for that view?
Yes, Your Honor.
Okay. All right, now court officers, Chief Rose usually gets the bus. So, all right, so for that, so the defendant's motion, it's our paper 283. Defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. So I'll hear whoever's arguing that for the Commonwealth. The Aruba incident, if you will. I mean, I'm sorry, who's arguing for the defense? That's what I'll hear from.
I am, Your Honor.
Okay?
Thank you.
Did you say 282 or
283.
282? Dr. Davis, please.
Oh, this is all backwards. Pauline did this for me. All right, thank you.
Thank you.
Thank you, Your Honor. The Commonwealth seeks to admit irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence against Ms. Reed by admitting inflammatory evidence of an event that purportedly transpired in Aruba on December 31st, 2021. As the court knows, this type of propensity evidence is extraordinarily prejudicial and serves no purpose other than to assassinate Ms. Reed's character in the eyes of the jury. The Commonwealth has put forth no reliable evidence to suggest that the incident that occurred in Aruba on New Year's Eve has anything whatsoever to do with O'Keefe's death, or that this remote and isolated incident was even a point of contention in their relationship at the time in question. And we aren't left guessing, Your Honor. All of the witnesses who were present at the Waterfall Bar and Grill on January 29th, 2022, along with high-quality video surveillance footage from that night, established that Ms. Reed and Mr. O'Keefe were happy, they were in good spirits, they were getting along. There is no evidence to suggest that this incident had anything to do with the facts at issue in this case. The Commonwealth points to purported angry voicemails left on the decedent's voicemail to suggest that there was some sort of hostile relationship between Ms. Reed and Mr. O'Keefe that night. However, these voicemails were left after Ms. Reed dropped O'Keefe off at Brian Albert's residence and after he failed to come back outside to meet her. There is no logical relationship between the prior bad acts evidence in this case that the Commonwealth seeks to admit and the crime charged here, and therefore this evidence must be excluded.
Okay, Commonwealth?
Yes, Your Honor. So this also relates to Commonwealth's motion to eliminate number 20.
Yes.
So in regard to that, Your Honor, this is highly relevant evidence as it pertains to motive and as it pertains to the nature of the relationship between Mr. O'Keefe and Ms. Reed, which goes to motive, it goes to absence of accident, goes to motive, absence of mistake. And this is not a, as the defendant seems to continuously try to pose it as some sort of temporary or isolated incident. This isn't just the argument or the yelling of swears between the defendant and Ms. Sullivan in the lobby in Aruba. This then leads to an argument which both children indicate in their statements continued inside the room in front of them for about 20 minutes after it happened. This is also not a fleeting reference in the sense that the defendant continuously brings it up on her own. Specifically in text communications with Mr. Higgins when she's talking about the nature of their relationship. And it's not just the voicemails that the defendant leaves on Mr. O'Keefe's phone after the murder occurs in front of 34 Fairview. It's also text messages exchanged between the two of them in the days leading up to that, in which they discuss the nature of their relationship. You also have statements from the children which indicate that the victim had tried to break up with the defendant multiple times in front of them. them, asked her to leave the home, and she refused. You also have a text communication from Mr. O'Keefe to Ms. Reed in which he indicates that he thinks that their relationship is essentially run
What
its
was the
course.
date of that one?
I believe that was the 28th. Then there's other text messages from the defendant to Mr. O'Keefe referring to their relationship between themselves and with the children as toxic. These are further statements regarding infidelity which continue on to the morning of, in which statements that she makes in the backseat of the vehicle with Ms. McCabe and Ms. Roberts as they're looking for Mr. O'Keefe just prior to locating his body on the front lawn of 34 Fairview. These are statements regarding her belief of Mr. O'Keefe's infidelity that she repeats again when she's having her recorded interview with Ms. Voss from Boston Magazine. These are not isolated statements. These are not just one time 4 weeks prior. It's not too remote in time, and it does show sort of the nature of the relationship and as it's evolving over the course of that month from the date of the incident in Aruba all the way through until the date that Mr. O'Keefe is killed. In furtherance of that, also, there are statements that the defendant makes to paramedics when she's being treated on scene that the last time that she saw Mr. O'Keefe, they got into a fight or an argument, and she's upset because that's the last time that they spoke was during the course of a fight or an argument in front of the house on Fairview Road. So it literally continues from the Aruba incident all the way through to the murder's occurrence. So for those reasons, the Commonwealth would submit that it is relevant as to motive, it is relevant as to absence of accident, and it is relevant as to absence of mistake. Thank you.
All right. What I will need is exactly what the Commonwealth intends to introduce. I think you've outlined it, and I'm familiar with it. If I admit it, it would certainly be accompanied by very strong curative instructions, which you know is my right. I've heard argument now. I'm going to think about this and maybe decide it by this afternoon, but.
Okay. Thank you.
Okay. All right, so you were both in agreement on what's the defendant's motion to exclude irrelevant and prejudicial evidence regarding alleged harassment and/or intimidation of a witness, and the Commonwealth's for different grounds and different scope, actually. Motion to exclude mention of Aiden Kearney, AKA Turtle Boy, and his pending criminal charges for witness intimidation. So, though you both agree it's out, that doesn't necessarily mean that I agree with you that it should be out. I understand that the nature of the harassment, mindful of the grand jury minutes that I've read, that in response to some of the questions posed by those at the U.S. Attorney's Office, the answers explained away some conduct as a result of the extraordinary harassment witnesses were undergoing. So I'm not sure I agree with you. So go ahead and try and persuade me, but what I'm inclined to do is keep it out in the case in chief, but Commonwealth said you told your witnesses not to discuss it. So I'll hear the defendant.
Just moving on.
I guess I would start, Your Honor, by saying that in order for evidence to come in, it has to be elicited by a party. It has to be offered by a party. You're being told that the Commonwealth does not intend to elicit this evidence and that the defense does not intend to elicit this evidence. So I guess the question that I would direct to the court is, do you intend to follow up with questions?
I'm not questioning the jury. It's clear that it may be a response, a natural response by a witness that neither one of you intended to get as a reason for something, that I'm not going to sanction the witness because I allowed the Commonwealth's motion.
Sure. So
Mr. Yannetti, so it's clearly you try your case the way you want to try your case, and the Commonwealth decides how they want to do it. But I am not tying the hands of witnesses to natural responses to questions. So I'm taking this under advisement. If you open the door, it comes in.
Oh, I completely understand that, Your Honor. I will say that I think probably, I don't want to speak for Mr. Lally, but I think...
So don't speak for Mr. Lally. I'll hear from him in a minute.
I'll speak for myself then, if the court will allow me, which is that if a witness opens the door to, a further explanation of this, that could give rise to both sides exploring that, which, I suppose we'll deal with that when it comes to it.
The way the motion's written, it would be prohibited, and witnesses, I'm not tying the hands of witnesses to natural answers that are the result of questions asked by counsel.
Right, understood.
Okay, do you understand that, Mr. Lally?
Oh, absolutely, Your Honor, and that was not my intent, is if a
How the
question...
motion reads, your motion reads, Mr. Lally.
I understand, but it was more of a notice that the Commonwealth doesn't seek to introduce any evidence of that, but at the same time, obviously, if the truthful and honest answer to a question that's posed of a witness references that, then I think it comes in.
All right. So I think we're all on the same page. Neither of you intends to introduce this in your cases, but if you open the door, or if it's a natural response from a witness, it comes in. Okay. All right, so Jim, is 289 defendant's motion eliminated to exclude the plasma, serum plasma, the alcohol testing? Or are my numbers all off?
That's 289.
Yeah. All right, and the Commonwealth has a paragraph or two responding in one of your other motions. So I will hear the defendant on the motion regarding the testing of the blood from the hospital for the alcohol levels.
Thank you, Your Honor. I'll be addressing this with the court's permission. This is number, just so we keep it clear in my head, I had named this number 17, dealing with the retrograde extrapolation.
Okay, we don't have it as 17 anywhere.
I thought that was the list that the helpful list that the Commonwealth.
Oh, okay, our number is 289.
Right, okay, so.
And the Commonwealth's one paragraph response is 17, but you filed the motion, so why don't we hear from you as the moving party?
Thank you. So the Commonwealth wishes to have Ms. Reed's retrograde extrapolation records admitted over, naturally, a hearsay objection, because the Commonwealth, their position is that they are medical records. The Commonwealth misapprehends the definition, the base definition of what a medical record is. A medical record, as the court well knows, holds a very special place in the evidence code, and that's because it's not compiled in anticipation of litigation. And for that reason and that reason only, they're deemed non-testimonial and not subject to Crawford and the defendant's right to confront and cross-examine witnesses or the experts behind the reports. Medical records are different than what we have here. The extrapolation records we have here are not medical records that were generated for treatment or Ms. Reed's medical history. They're the opposite. Those records were generated specifically in anticipation of litigation and in association with this criminal investigation. Thus, they are rank hearsay. The Commonwealth claims that the records are not produced in anticipation of litigation, stating basically that during her hospitalization, law enforcement was at the, quote, beginning stages of their investigation. But what the Commonwealth fails to mention or address is that at approximately 6:30 a.m. on a dash cam video, an Officer Good, as a matter of fact, a Canton police officer, states to Detective Lank that he is going to, quote unquote, section her, which the court knows what that phrase means. He's going to place a hold on her medically. Thus, the clear intent of law enforcement hours before the blood draw was actually taken was to keep her under law enforcement's thumb as she was an immediate suspect. But there's a bigger issue, Your Honor, and that is that the parties lack the essential, and by the way, this goes to the Commonwealth as well, the Commonwealth, but more importantly, the defense, we all lack the essential information on how the blood was actually drawn and tested. Those standardized protocols that we all get used to in the average OUI case, drunk driving case, they don't exist here. The standardized protocols for reliable testing, they're tried and true, and every one of those protocols is missing or are missing, and that leaves the defense having to sort of guess at the validity of the underlying test, and the validity of the underlying test is the foundation on which the extrapolation is made, which is the only thing the Commonwealth really cares about. They don't care about the underlying test, they care about extrapolating backward several hours. But this sort of goes along the theme of garbage in, garbage out. If the underlying test was not valid, or it can't be proven to be valid, then, of course, the extrapolation is also invalid. The question remaining is, was the testing done by gas chromatography? Was it enzymatic testing? We don't know, and we'll never find out. We don't have reports to suggest that, or exactly what the validity of those tests were. So the initial result is suspect, and by extension, the extrapolation is also suspect. It bears pointing out, Your Honor, and this is the only sort of granular detail I want to get into, the extrapolation, according to the Commonwealth's expert, is somewhere between 0.13 and 0.29 blood alcohol concentration. That is a swing of more than 123%. In other words, the swing of the extrapolation is larger than any one of the numbers themselves, which means it simply cannot be reliable. It illustrates the invalidity of the underlying serum plasma test, and for those reasons, the defense objects to the admission of both the blood test, the underlying test, as well as the concomitant extrapolation.
Okay, thank you. Kamala?
Your Honor, so what the Commonwealth would submit is this may have been a valid basis for a motion to suppress, but it was a motion to suppress that was never filed, and one that the defendant specifically waived, that Mr. Yannetti waived all motions to suppress. As it pertains to Mr. Roberts from the Office of Alcohol Testing's testimony regarding the serum conversion and the retrograde extrapolation, the reason for the range is because it's math, and essentially taking into account a number of different variables. That is why the range is as it is. As it pertains to the specific item that would be introduced into evidence, meaning the defendant's medical records, that's what the Commonwealth is referring to as the records coming in. Mr. Roberts would come in and testify as to his own analysis, his mathematical calculations, and the results based on his training and experience, which the defendant has had for over 2 years, as Mr. Roberts testified at the grand jury to that exact set of scenarios. As it pertains to the testing itself, the Commonwealth, as indicated on its proposed final pretrial memorandum, has summoned in not only the doctor who ordered the testing, the registered nurse, the nurse practitioner, who would both have been involved in the taking of the sample from the defendant pursuant to her medical treatment and medical diagnoses, as well as the director of the lab at Good Samaritan Medical Center, who would testify as to what kind of testing is done and the nature of that testing and everything else. As it pertains to those witnesses, if the defendant wishes to conduct some sort of voir dire prior to the testimony in front of the jury, I certainly have no objection to that. But any sort of voir dire of Mr. Roberts or exclusion of his testimony would be inappropriate based on the fact that the defendant has had more than ample notice as to what the parameters of that testimony would be. So as far as what would be coming in as an exhibit, it would be the medical records with that amount in it, and there would be testimony from essentially anyone and everyone involved in the ordering, taking, and analyzing of that particular sample, which then provides the basis for Mr. Roberts' testimony.
Okay. So I have like one small paragraph from the Commonwealth on this. I want a memo on this.
Sure.
All right, so I'll take this under advisement.
EM 17. And they're 17.
Yeah, there's 17 we still need to address some of. All right. So that's all of the defendant's motions in limine, correct, Mr. Yannetti?
Let me just have a moment.
Mr. Jackson, it's all of them, isn't it?
We filed a motion for attorney-conducted panel voir dire.
Yeah, that's a joint motion, and that's, I already said we're going to talk about impanelment this afternoon.
Just being complete in answer to the court's question. That was one that was not addressed, but that's fine.
All right. Oh, the request just to have panel, your motion was a little bit confusing.
Right.
So you want panel voir dire?
Panel voir dire, correct.
I'm not going to do panel voir dire in this case. So we'll talk about the particulars of it later this afternoon. All right, so on the Commonwealth's list of motions, you said that there are some that you may agree with. What besides the view? Are there any of these numbers?
Yes, Your Honor. The defense does not object to the Commonwealth's motions in limine numbers 1 through 6. Number 8.
1 through 6.
Yes, number 8. Number 9. Number 11, we obviously joined in that request.
Yes.
Let's see. Number 14, we do not object to. Number 15, we have no objection in principle, but we do reserve the right to object to just individual exhibits as they come.
Yeah.
Number 18, we have no objection. Number 19, we have no objection. Number 23, no objection. Number 26, no objection. I believe the court
That's
did
the one
address
we
that.
addressed, yeah.
And number 32, we have no objection.
All right, thank you. All right, Mr. Lally, I will hear you on our paper 297, your number 7.
So, Your Honor, this is the Commonwealth's motion to preclude reference and redact the manner of death contained on the victim's death certificate. This is a routine motion the Commonwealth files in really respect to any case. Manner of death.
That's not persuasive, so go ahead.
No. And I'm just, manner of death, as elucidated in the motion, is not something that is typically something that is permissible to be testified to from anybody to the jury, because that's sort of the question of liability ultimately that is left to their discretion as far as how they find the facts. But cause of death, obviously, is something that is a medical determination. Manner of death, as the court is well aware, is there are essentially 3 or 4 different selections, and they fall into different categories. They don't necessarily mean in the medical context what they might mean in the legal context. So for that just sort of simple differentiation of meaning between the two, manner of death is not something that the Commonwealth feels is appropriate for the court, for any witness to be testifying to as far as the jury is concerned, as that's a question for them ultimately to determine. And for those reasons, the Commonwealth would ask that this motion be allowed.
All right, who's responding to this?
Thank you, Your Honor. The medical examiner who completed the death certificate in this case concluded that the manner of death was undetermined. The Commonwealth now seeks to have that portion of the death certificate redacted because it is quite clearly exculpatory. All of the cases cited by the Commonwealth deal with the issue of whether it was error for the Commonwealth to admit a death certificate listing the manner of death as a homicide, because it violates a defendant's right to due process and a fair trial under the 5th, 16th, and 14th Amendments to the United States Constitutions. None of the cases cited by the Commonwealth stand for the proposition that a medical examiner's determination that the manner of death is undetermined should be redacted. In fact, the Commonwealth cites Commonwealth versus Ellis at 373 Mass 1, it's a 1977 case, for the proposition that excluding the word undetermined is the better and safer course. But that's a misstatement of the law, and I would urge the court to read the Supreme Judicial Court's opinion in that case. What it actually says is this, quote, "Nothing contained in the record of a death which has reference to the question of liability for causing death shall be admissible in evidence. The better and safer course is to exclude from a death certificate the words homicide, suicide, or accident in a criminal trial." Notably missing from that list of words that the Supreme Judicial Court warned about is the word undetermined. That is what the Commonwealth seeks to have redacted here. The Commonwealth bears the burden of proof in this case. They have to prove beyond a reasonable doubt that a homicide occurred, and their own medical examiner has opined that she was unable to make that determination. That finding is relevant, it's exculpatory, and there's no authority that supports its redaction. Thank you.
All right. Mr. Lally, the medical examiner will be on your witness list, right? I haven't seen either of yours witness list.
Yes, Your Honor.
Okay. So I'll take this under advisement. All right, Mr. Lally, you're number 10, our number 300.
Yes, Your Honor. In this motion, the Commonwealth is simply seeking to obtain CORI information or records of potential jurors. Not looking for information pertaining to jurors that, as they come in, or some voluminous amount of every possible potential juror, but only seated jurors. And essentially, what the Commonwealth is requesting is to simply have some sort of verification that the answers that are provided by the jurors are true and accurate. This is something that is permitted by the case law, it's permitted by the statute, and it's obviously something that the Commonwealth would share with the defense as required to, but the timing of it, of what I'm asking for, and the limited scope that I'm asking for in relation to just seated jurors once we have a full sort of set of jurors, whether that be 12, 16, whatever the court chooses as far as the number, I'm assuming approximately 16 or so. But once those are seated, the Commonwealth is just asking for some time to run those queries and provide those to counsel, and then make any further objections for cause prior to the jury being sworn.
Okay. So I know you're not in agreement. Are you opposing this?
Yes, Your Honor. Your Honor, we object for several reasons. First, the jurors are given a questionnaire which specifically asks this question. They self-report. We rely on self-reporting from jurors with regard to all questions. The Commonwealth has cherry-picked this one question to verify whether or not they're telling the truth without dealing with any of the other questions that the jurors are asked. This proceeding right now, like many of these proceedings, is being broadcast widely, publicly. There are potential jurors out now listening to this, I'm sure, waiting for an answer from the court as to whether or not they will undergo that further invasion of privacy. And they are also, I would submit, aware that in this unusual case, the Commonwealth, through their special prosecutor, has sought to charge picketers, protesters in a very unusual manner, we would claim a harassing manner, and our position is that this is just another method of harassment. We believe it's unfair. We ask the court to deny this motion.
Do you have any case law to support your argument, Mr. Yannetti?
Your Honor, the case law is simply the constitutional rights to privacy that the jurors have. I mean, it's an issue of fairness, Judge. So that's what we're relying on.
All right. So the motion is allowed, Mr. Clerk, number 300.
Thank you.
All right. Mr. Lally, you're coming into number 12 with me quite skeptical. Number 12, leading questions for 13 and 16-year-olds.
And again, Your Honor, let me just first start by saying I don't think that this is something that's going to be absolutely necessary, given what I know of the two child witnesses in this case. Only filing under abundance of caution, more so should the need arise based on less so the age of the child, but the age of the child taken in conjunction or in the context of sort of the atmosphere of testifying specifically in this case, in this courtroom, with different things going on as far as the amount of people and things of that nature. So again, I don't foresee this being an issue, but just an issue that I wanted to flag for the court. Should it become an issue, and seek sort of the court's ruling or permission in regard to it prior to any sort of incident arising.
Okay, given that caveat, is there any objection?
No objection at this point, Your Honor. We can address it as it arises.
Okay. Mr. Lally, keep in mind the jurors would much rather hear from the witnesses than from the Commonwealth.
Of course.
All right. Mr. Clerk, on that, we're just going to withhold ruling. Withhold ruling until a later time. Commonwealth, you'll raise this again if need be.
Yes, sir.
All right. All right. So on your next motion, your number 13, I had it. I don't have it in order. Just give me a minute. So I'm curious. Do you happen to have? Oh, we don't have the screen up. Do you happen? I'd like to see exactly what it is that you intend to introduce. So this is your motion eliminate to admit evidence that the defendant was in custody for a period of time after her arrest. Jim, is it possible for you to print that for me?
13.
Yes, please. Thank you, okay. All right, I'll hear you on this, Mr. Lally, and remind me the date that this body cam footage was taken.
So, Your Honor, this is in reference to the defendant's arrest post-indictment by the grand jury in this case. So it's June 9th, 2022.
So that's why I have not seen the video itself.
Correct, and that's certainly something that the Commonwealth can provide for the court. But essentially, when she's arrested and during the booking process at the Milton State Police Barracks, the troopers who conducted that arrest were wearing a body-worn camera pursuant to their BWC policy with the state police. Counsel has a copy of the policy, counsel has a copy of the video, and essentially there are a number of different statements which provide sort of third, fourth, fifth, sixth, I'm not sure what number we're up to at this point, of sort of varying accounts that the defendant has provided to numerous people.
Can you give me an idea now? Do you know the substance?
So the substance of these particular statements is the defendant, Ms. Reed, continuously is told by Sergeant Buchanan to essentially stop talking. He's advised her of her Miranda and advised her to stop making statements, and repeatedly states that to her during the course of her making statements. But the sum and substance of it is she says something to the effect of, you know, are you in on the joke? And then makes some sort of reference to having witnessed Brian Albert and Colin Albert essentially smash John O'Keefe's head into the taillight, indicating that that's how her taillight was broken. Doesn't make any sort of further statements about why she would then leave the scene after that occurred or anything like that. But these are, again, different accounts that have been made in direct variance to prior statements that she made January 29th to the troopers, to paramedics, to treating medical professionals, to Ms. Roberts, to Ms. McCabe, to the niece of Mr. O'Keefe, to a whole other sort of slew and variety of people with a different sort of variation on what transpired each time. So it's sort of inextricably intertwined with the fact that she's in custody.
How so? Is she in handcuffs? Is she in a cell?
She's seated at the booking desk or the booking rail in the State Police Barracks. So, I mean, I don't need to make direct reference to it. It's just, again, it's something out of an abundance of caution based on sort of where it is and when it is that the statements are made, that it may naturally sort of come out as far as if the court wishes. I think it's something that the court can cure by issuing a curative instruction if there's any prejudice to be suffered by the defendant. But again, it is a statement by the defendant, which is admissible, as the court is well aware. And then it is sort of in the confines or in the context of her being in custody when she makes that statement. I certainly wouldn't be trying to elicit testimony that she was in custody, but it is kind of apparent that she is.
Can you have that here for this afternoon,
Yes, I can arrange for that.
so we can see it?
Sure.
All right, what's the defendant's position here?
We object. Your Honor, we're in a situation now where the Commonwealth arrested Ms. Reed twice when they didn't have to. I made the argument to you at arraignment back in June of 2022 that after John O'Keefe was found dead on the lawn of Brian Albert's home, I immediately got a letter out to the state police saying, I represent her, I will surrender her, no need to arrest her, just call me and I'll bring her in. They ignored that and they arrested her to get her into custody. I would assert ultimately to make the arguments that Mr. Lally's making today. Then, astonishingly to me, after the grand jury issued indictments, based on basically no new evidence, they upcharged her and once again did not contact me, despite the fact that she was completely in compliance with the terms of her release and had made every court appearance. They arrested her again. And so, again, I would assert to be in the position that they are in today. With regard to the case that they cited, Your Honor, Hoffer does not stand for the proposition that they claim that it does. In fact, the issue of that defendant being taken into custody was stricken by the court. The testimony in that case that was allowed or sanctioned by the SJC was evidence that the defendant had been living with his girlfriend but had unexplained absences. He didn't get along with her son. She was afraid of him, and that he associated with a convict that made her nervous. There was nothing about him being in custody that was admitted in that case. To the extent that these statements are, or the court deems these statements to be relevant and admissible, there are other ways to do it. I do urge the court to watch the video.
Yeah, I think we'll put it on the screen because I want to see how the jury would look at it.
Okay, that's fine. But I will suggest, Your Honor, that there are other ways to accomplish that, either to have testimony about what it was, or failing that, to have the audio of my client making whatever statements they seek to introduce without the video. An image of my client, in handcuffs at a police station is what this court generally tries to avoid, given the fact that as she sits here and as this trial is ongoing, she's presumed to be innocent. We wouldn't bring her up here in an orange jumpsuit and then ask the jury to make decisions about her, nor should we display her after a perp walk at the police station in handcuffs, making these statements.
All right, so I need the Commonwealth to, do you have your media person available, Ms. Gilman or Ms. Crawford or whomever?
Yes.
All right.
We're seeking to make arrangements for that.
All right, we'll put it on the screen just so I can see how the jury would see it. All right, thank you. So we'll look at that this afternoon. All right, so I'll hear you on the celebrate motion, your motion number 16, Mr. Lally.
Thank you, Your Honor. So in this motion, what the Commonwealth is requesting is for permission for the Celebrite expert, Mr. Whiffen, to conduct a demonstration in the courtroom during the course of his testimony in regard to the examination that he did in regard to Ms. McCabe's extraction report, and specifically the alleged search, which the defendant purports occurred at 2:27 in the morning, and the Commonwealth maintains occurred at 6:23 and 6:24.
I'm going to stop you because one question is, how long will this take if we allow it? How long will the demonstration take?
So really what I'm seeking to do ideally would be for sort of a live demonstration, which I had Mr. Whiffen do and record, and provided a copy of that to counsel as well. So that recording that I provided has no audio to it, but there was also a PowerPoint presentation that Mr. Whiffen prepared in relation to the same issue that he produced, and then I provided that to counsel as well, which essentially goes through what he did, and it also...
You're not looking to do a PowerPoint presentation, are you?
No. The PowerPoint presentation would not be something I'd be looking to admit. The reason I did the video is in the event that technology is not our friend on that particular day and the live demonstration doesn't work, I would then be seeking to introduce the video and have him talk about it while it's playing. It mirrors essentially or exactly what Mr. Whiffen had included in his report, which was done back in almost a year ago at this point, and has been provided to counsel, and is essentially the same thing as what's contained in his report, but just as far as a visual aid and demonstration for the jury. I just think it's a bit when particularly talking about sort of the technical aspects of his particular analysis, the Commonwealth would submit that it would be helpful and assistive to the jury in order for them to have that sort of visual demonstration to go along with, obviously, the oral testimony of the witness as well.
All right. Who's arguing this for the defendant?
Thank you, Your Honor. We received from the Commonwealth the video that Mr. Lally just described about 48 hours ago. So we have not had an opportunity to confer with our expert about that particular issue.
Okay.
However, just from sort of a cursory review, it does appear that its admission is improper. As the Commonwealth acknowledges in its motion, in order for the court to allow a courtroom experiment or reenactment, there are very strict rules concerning that experiment. It has to replicate with exactitude the actual event so that it is fair and informative for the jury. Otherwise, it's prejudicial and would serve only to confuse the jurors. Here, just based on a cursory review, it does not appear that Mr. Whiffen's in-court experiment replicates all of the factors that we know were in existence at the time in question.
Does it replicate the factors that he says he considered?
So I'll need to have a little additional time if the court doesn't mind to confer with my expert.
Yeah, so I will give you time to confer with your expert and file a written response. But that's one of the factors that I'm asking you to look into.
Understood. And then just, if the court does intend after a written briefing to consider admitting that evidence, we would ask to be able to take their expert on voir dire as to that particular issue.
Okay.
Thank you.
All right. How much time, Ms. Little, do you think you'd need to confer with your expert and put something in writing?
I believe about a week should be sufficient, Your Honor.
Okay.
Thank you.
And I'm sorry, I neglected to answer the court's question as far as timing. The video demonstration, which is essentially what I'd be asking him to do, is about 19, 20 minutes.
Okay. All right. So, Mr. Clerk, that's under advisement.
Wait.
So what remains on Commonwealth's motion 17? The statements, so there's... So I know this also went to the blood draw, but there were statements. That's what separates this from the defense motion to exclude the testing. So I'll hear you on that.
Sure.
Is the defense objecting to that portion of the Commonwealth's motion?
Thank you for that opportunity. Not particularly, no. It's the blood draw and the extrapolation.
Yeah, so the motion had both, so that's why, all right, so I guess we don't need to hear, so the part of your motion that concerns the statements made by the defendant, the defense is not objecting to.
No, very obviously, they're admissions, and everybody knows what the rules are dealing with admissions. So I'm not concerned about that.
Okay. All right, so Jim, on 307, it's a split. The Commonwealth is permitted to introduce statements made for purposes of medical treatment. And the certified medical records. But there's an objection as to what we've heard regarding the alcohol testing, the blood testing for alcohol. Okay. All right, you're number 20, Mr. Lally. Our number
20, Your Honor, I believe, refers back to the same argument that the Commonwealth had made in opposition to the defendant's motion to exclude anything about the nature of the relationship.
Okay.
Things of that.
That's why I don't have it right here. Okay. 21, the out-of-court statements regarding the victim's state of mind.
So 21 sort of pertains to that same issue as 20. So essentially, it's the same argument. You're on the same facts underlying it as far as statements that the victim, Mr. O'Keefe, made to. But
were you making statements regarding like bins in those cases, Commonwealth versus bins, the state of mind of the defendant, state of mind of the victim, the defendant knowing it, the defendant being able to act as a result specifically? Okay.
So on that sort of specific application of, and that's why we filed two separate motions in relation to it. But as it applies to that, the Commonwealth would submit it as clearly met its burden under the case law as it applies to that because of the nature of some of those communications. So it's not just communications that are observed by other parties as far as what the victim, Mr. O'Keefe, indicated to Ms. Reed, or these aren't situations like in some of the case law where it's an indication to a third party and the defendant wasn't present, and then there's sort of an inference that can be made that, well, if they're saying it to this friend of theirs, then they must have communicated that to the person with whom they were in the relationship with. In this instance, Your Honor, we have direct communication between Mr. O'Keefe and Ms. Reed via text communications from each of their phones indicating that that communication about ending the relationship was made just prior to the date of his death in this particular case. So it not only enhances, but what I would submit is corroborates that testimony from other sources or from other family members and other witnesses. So for those reasons, the Commonwealth would ask that its motion be allowed.
All right.
Your Honor, on this motion, our position is that we'd like more specificity about which statements the Commonwealth is indicating they seek to admit. I imagine
That's the same thing I said to you, Mr. Lally, on the other one that was
right.
In connection with this. So the Commonwealth will do that?
Yes, Your Honor.
Okay.
And I think then at that point we can evaluate it, Your Honor. Certainly some of these statements are going to come in, but we'd like the opportunity to be able to object if they are
No,
not admissible.
I agree, so it has to be clearer. So, as far as your notice to the defense, you can even point to grand jury minutes or whatever, but I need to know the statements you intend to introduce.
Understood, Your Honor. And what I can do and what I aim to do, just sort of an ancillary thing, is I'd like to, if the court is amenable and counsel is amenable, to pre-mark as many exhibits as possible, just to make the situation easier for both sides as far as referencing documents, photographs, videos, things of that nature. So when it comes to, I'm not seeking to introduce, when it comes to any sort of the cell phone extractions, I'm certainly not opposed to admitting the entire extraction dump essentially from anybody's individual phone. But what I'd like to do as far as exhibits are concerned is to print out or create sort of extraction reports from those cell phones as far as different communications between person A, person B, just to make it more simple for the jury to digest it and more simple for, I think, everyone involved to understand sort of the exact communications that we intend to talk about. So in that vein as well, what I can do is provide a supplemental memorandum in regard to 20 and 21, referencing sort of those specific conversations.
Okay, that'd be great. And if you can work together, and this will be part of the housekeeping we talk about this afternoon, work together to pre-mark exhibits, that would be great. All right, so 22.
So again, with respect to 22, and I think the same can probably be said for 23 and 24 and 25, is that essentially, as I've stated earlier, the Commonwealth is somewhat operating in the dark, and that I don't have any discovery, I don't have a witness list, I don't have any investigator reports or notes or notice of an expert or notice of any sort of expert reports, curriculum vitae, really anything. So out of an abundance of caution, the Commonwealth filed motion to eliminate numbered as 22, which is in reference to any alleged bad character or any prior misconduct of the victim or any witness that the defendant alleges to seek to elicit through whatever witnesses they may or may not have. But essentially, what I would state in regard to this specific issue is that, as the court is well aware, it has to be something that is, first of all, relevant to anything, and it also has to be relevant to a reputation and not just an anecdotal something that's brought up from one witness, again, who I don't even know who those witnesses would be at this time. So I don't know that the court can rule on it without any sort of notice as to whether or not the defendant intends to seek to introduce such evidence or has any such evidence or who those witnesses would be or what their level of knowledge would be, but it's something that I at least wanted to flag for the court in regard to if it comes up as we go along.
Who's responding?
That would be me, Your Honor. Thank you.
Okay.
This will be very brief. The Commonwealth, at least in their moving papers, Mr. Lally, I think, has gently stepped back from the moving papers a little bit. The moving papers suggest that they seek to preclude the defense from presenting any evidence to the jury that one or more of their witnesses lied or gave false information in this case in any particular. They call this, they do this under the rubric of bad character, but that misunderstands or misapprehends what bad or what character evidence actually is. Character evidence or bad character evidence refers to using past behaviors or past traits of a person to prove a propensity to act in a certain way in the future. Conversely, proving that someone lied or gave false or misleading information in regards to a specific matter that's relevant and material to the case at hand, that's called impeachment. And that's allowed in every single courtroom across
So impeachment's certainly allowed, but do you intend to put on witnesses regarding challenging character evidence?
No, we're not intending to. That's exactly what I was going to summarize by saying the bad character focuses on general character traits, whereas impeachment deals with people who lied or were untruthful. We intend to do the latter.
Hold on, Mr. Lally, you're not objecting to impeachment, prior inconsistent statements, things like that?
No, of course
so
not.
So Counsel, you mentioned that there is a distinction between character evidence and straight impeachment. Character evidence is not permissible because you're not going to introduce it, you said, right?
We're not seeking to introduce it at this point, and we wouldn't. I mean, obviously, the trial has to play out, and it's going to be several weeks. And by the way, Mr. Lally has mentioned over and over and over about how he has no reports and no statements, et cetera. He's got more than 7,000 reports and statements, both from his own investigation and from the federal investigation, that in no small part encapsulates a lot of what we intend to impeach with. However, as I stand here today, I can report to the court that we don't intend at this juncture to put on bad character evidence. We don't know what that might look like, but if we did, obviously I know the rules. I would give the Commonwealth due notice and the court notice before we went that direction.
All right, so 312, Mr. Clerk, is allowed. If you need to readdress that, defense counsel, you need to file a motion, okay? So 312, Jim, is allowed. Same thing, do you intend to put on character evidence? It's a difficult standard or potentially problematic, but do you intend to do it?
Your Honor, we at this juncture do not intend to put on character evidence, but we will give the court notice as well as Mr. Lally notice if we do change our mind.
All right, so 313, Jim, is allowed and defendants can renew it.
I'm sorry, what was the second part?
Defendants can renew it
Yeah.
by written motion. How about 24? Is there an objection to that?
I believe that was 24, Judge.
No, that was.
No, it's 23.
Oh,
did
I apologize. 23, we had said we had no objection.
Okay, I didn't have
And
that.
24 is the opinion or character.
Okay, so 24 is, all right.
I'm sorry.
24 is allowed, Jim? 23 and 24 are allowed. All right, there's an objection to 25, Ms. Little? Just
Yes,
yes
Your
or no?
Honor. Mr.
All right,
Jackson is-
so I'm going to hear from Mr. Lally on the motion. I just wanted to know if there was an objection.
Your Honor, I could probably, if I don't mean to step on Mr. Lally's toes. If he wants to talk, he can talk. We don't anticipate asking any of our experts to read from a treatise. If that's what his concern is, and that's how I read the motion, we don't anticipate going there. That might short circuit this.
So no treatise, no studies?
They will refer to studies, they're not going to read from studies on the witness stand at this point, at this juncture. Certainly, their studies are the foundation of every expert's testimony.
Okay, but what he's saying is he has no discovery of even who your experts are, so how's he going to read all these articles?
I understand that. As the court knows, and we anticipate, and I think Mr. Yannetti is going to address this with the court soon enough, he will be getting our expert reports. We now have, finally, their final notice of what their discovery is.
Certificate of compliance.
And we are anticipating by the beginning of trial, by Tuesday, to have something in response to that. But no, we're not going to elicit an expert to sit there and read from a study or read from a treatise, if that's what their concern is.